attorney tell me, you know that this is not a manifestation of this student's disability. He said that to me. He, as an attorney, said, your student made a threat. Your student has a IEP that addresses some neuromuscular concerns. Therefore, you know it's not a manifestation, Ruth. And that doesn't matter. It doesn't matter that the school side lawyer thought it wasn't. It doesn't matter that the principal thought it wasn't. We still get the hearing. Our student still gets the chance to present what happened and go through the process that the IDA affords. We'll go to the next slide. Okay, so we're going to talk about a student here. His name is BB. BB is a student who has a diagnosis, a medical diagnosis of ADHD. However, BB, and we'll talk about this a little bit later, BB didn't currently have a documented IEP or 504 plan, but the evaluation process was underway when this happened. BB, bunch of friends are on the school bus using profanity, being obnoxious as middle school boys do. It was after school. I think it was a sports related event. Excuse me. And BB started using a lot of profanity. On this bus video, which we were able to hear, he was making some horrible comments about another student. He was directing these taunts and teasing and victimization toward another student. Very, very hurtful language. And because of that, and because the victimized student came to the school with their concerns, the school decided to propose an expulsion for BB. So we went to BB's hearing, and BB actually brought his county support provider to this meeting. And this county support provider was there along with myself, the parents, the student. The superintendent and principal attended this manifestation hearing. It was a small county, so I think the superintendent got really involved in these. And because expulsion was on the table, he wanted to be there at the MDR. And also the vice principal, who had a lot of knowledge of our student. And it was actually a really great meeting in that it started as a conversation. We're going to see later kind of the checklist that schools are required to use for the manifestation process. But this one started as a conversation. The unique thing here is that this manifestation determination meeting included someone outside the school team. And that's unusual for a few reasons. You need to know what that person's going to say there. You need to know that they're not going to bring in something more concerning about your student, but you also need to realize the implications for your student's privacy rights. These meetings are very closely held. So a word of warning that support people can be instrumental, and here it was instrumental because the superintendent and the principal, along with the assistant principal, were able to see that BB was getting help. It wasn't just that the parents had raised these concerns at school, the teachers had noticed maybe something else is going on. This was a real cooperative team approach. And so for that purpose, having that outside support person there to let the school know that they were on it, the family was on it, BB was getting help, and BB had expressed a whole lot of remorse for what he had said. there was kind of an informal stay away between these two students. BB did some subsequent watching of kind of anti-bullying programs that the school offered, and BB was found that his behavior on the bus was a manifestation. Again, this has an asterisk because he wasn't truly entitled to the manifestation determination yet, and it didn't follow that real that document that we'll see later. It was a little more informal, so he avoided expulsion, and BB's doing great. I would love to work with the school again. I love their approach here. Very supportive of BB, and I think this was a good one to start with. We'll go to the next slide, Renee. Okay, again, this is kind of the nuance of BB. If a student has an IEP or a 504 plan, they get that manifestation determination review. The next one is where BB fell, right? This student had a parent making a request that they think something else is going on with BB. He did have that underlying medical diagnosis, but did not previously have any special education services. But we also had school teachers raising concerns. I'm not sure if they raised those concerns to the special ed director, who was not at our meeting, or if those concerns were raised to the assistant principal and principal, but he was entitled to be there because those parents had requested that evaluation take place. Few areas where an MDR will be not provided as a matter of course, if parents have refused consent for special education evaluation. The school's going to take a hard line there and say, hey, we wanted to do an evaluation. You wouldn't let us. So we're not going to give you the benefit of an MDR, because had we done that evaluation, had your student been placed on a 504 plan or an IEP, the MDR would be a matter of right. Your refusal to consent to that evaluation means you don't get to have that protection of the MDR. Additionally, if parents refuse the services of the IDEA offering that the school has made, and lastly, if we go through that step 2, parents have inquired, we've done the evaluation, we found the student ineligible, there is no entitlement to have that MDR, but I'll also put an asterisk at the end there, because at a disciplinary hearing where a student is going to be proposed to be removed, I think you could make a really good case as a parent if you have raised those concerns, if it's well documented, and here data is your key, that you've made the request, that you thought something was going on with your student and your student was deemed ineligible, and then you have some sort of behavioral concerns that pop up that seem right in line with why you were asking for that evaluation. I think you could make a really good argument at your suspension expulsion hearing, if it's a suspension expulsion, or if it's a suspension for longer than 10 days without the expulsion, that you could say, hey, I think you guys missed it. This is exactly why I asked you for that evaluation. You found him ineligible. Let's relook at that again. So let's go to the next slide, Renee. So MT is the one I started talking about yesterday, but we didn't talk about it in terms of the threat, but we talked about it in terms of his entitlement to a MDR. So MT and his friends are on my least favorite social media app, Snapchat. If we could ban Snapchat, I think it would be a really positive move for schools. I'm not about banning student expression. I just think that kids get in so much trouble here because of how Snapchat works. As you will see for MT, he was at the time an 8th grader. He got into a Snapchat with a number of friends. The Snapchat grew. We have 12 students at least across 4 grades at this school involved in a very lengthy, I believe it was a Sunday night Snapchat. They're trash talking each other. And one of the participants, in MT's recollection, comes and says, they're going to rape MT's mom and blow up his house. MT responds that he would kill the other child's father. You see here, unbeknownst to MT, that child's father was a school resource officer in the district the student attended. That part about I'm going to kill your dad was screenshotted. The rest of the conversation with the raping of MT's mom and the other kind of very angry, violent threats by all the students were not all captured, but MT's was. A few other student statements were captured and were deemed inflammatory enough. I believe that there were about 8 kids sitting before the school superintendent with proposed expulsions because MT had a 504 plan in place. MT was entitled to an MDR, and we did go to that MDR. I'm going to echo back to what Megan talked about last time, and I always like to have a student read a written statement that they prepare in advance. We can give them tips and guidelines, but I think having a student, if they are able, explain their actions, explain what they did or didn't do, goes a long way, both in the MDR and in the subsequent expulsion hearing, if we go to an expulsion hearing. MT did read a statement. It was very well thought out. He explained his disability in that MDR meeting. He talked about how he felt like he immediately needed to respond to that student who said he was going to rape his mom. And he said something stupid. He admitted that he had no clue that the kid's father was a school resource officer. And in this case, MT's actions were deemed not a manifestation of his disability. For those of you who know a bit about oppositional defiant disorder, to me, this one was kind of an outlier. It seemed like there was a lot of back trash talk to his ADHD. We'll talk about his impulsivity. I believe in this case, the principal had to make a decision based on the number of kids involved in this Snapchat. And I think this principal was very concerned that a student who made a pretty serious threat would get the benefit of a second chance via an MDR ruling and be back in school the next day. It was especially problematic because of the fact that MT was very connected to this killing of a person in the snap, and lots of kids had seen it. So in this case, I'm not sure that, MT got a real fair shake at his MDR hearing. We spoke with the parents about kind of taking it forward. They just really wanted to be done with this. This was very embarrassing for them in the community. They thought MT needed a little bit of a break from being with his friends. He was subsequently expelled with some time of his expulsion held on abeyance. So he spent about a month out of school and then went back. We have not heard from him since. So I'm going to say that MT learned his lesson. But this is one of those where we're looking at kind of things happening in the background. We talked about one of my students yesterday who got maybe a little bit of a bonus because she was a school athlete. I think in this case, the nature of the number of people involved posed a real problem for this district in having a different treatment for a student with a disability when given the nature of his comments. We'll go to the next slide. So this is the form here in Ohio. It's hard to read, it's small. We talk about what's on it on the next page, but these are, because we're guided by IDEA here, pretty standard through the state. Some give a little bit more room to answer the questions. If we flip to the next slide, you'll see the pertinent parts, participants, and this will come up later in our question pop-up. Who's there? We've talked about some of the people who will come to an MDR: parent, student, relevant members of the IEP team. The classroom teacher is often a really good person to have at the MDR because they see the child day to day. School administrator, and there we have it. School administrators, attorneys for the student if the student has an attorney retained. In most districts, if the family brings an attorney, the district will also bring an attorney to the MDR meeting. The MDR meetings are generally not recorded. Here in Ohio, parent could record. I know the laws in Pennsylvania are different, and the parties need to know that it's being recorded, but in general, MDR meetings are not recorded. I would say the relevant members of the IEP team should always include a representative from the special education team. Generally, we have the director or supervisor of the special education team for the district. Some of the larger schools will bring the lead of the special ed team for the school. That's an important person. We'll hear later. That person generally gets the deciding vote in a difference of opinion whether or not the behavior represents a manifestation of disability. So on the previous slide, we saw, 4 little questions to answer. And the first question in the short form says, did the IEP team review relevant information in the student's file and the student's IEP? You see here on my slide, I've pulled that out a little bit. And when I go to an MDR meeting with a family, I get into it all. I want to look at grades. I want to bring up progress reports, teacher and staff inputs. I've already done this legwork. I've looked through that file. I've looked to see, did my student exhibit this behavior in the past? If I can find something in my student's file where that happened in the past and the school was on notice of it, I'm always going to point that out. Danielle and I talk about it a lot, but it's really hard to get an MDR ruling in your favor with ADHD and impulsivity when the behavior is so out of sorts for what this student has done in the past, for needing basic accommodations, a student subsequent behavior that is really out of character for that student, making threats, fighting, vaping. None of that is going to be supported just by having ADHD. We've added other considerations here. These considerations should come in. They should be talked about at the MDR. The medical evaluations, any diagnostic reports, even if I have a 3-year-old neuropsych evaluation, as long as the school has gotten that, I will read through that to see if this behavior is somehow brought out there. Because I want the school to say, hey, you heard that this student, when he's confronted, acts inappropriately, is disrespectful, walks out of the classroom, spends too much time in the bathroom, whatever it is, I'm going to bring it up. Because to me, that is relevant information in the student's educational file. And that's always where I'm leaning when I'm in these meetings. For the behavior giving rise to the proposed discipline, this is often where we have the student talk about what they were doing, how they were feeling through that prepared statement. I was in class, I was stressed out, I really struggle in math. I feel dumb in math, and the teacher was asking me to do X, Y, or Z, and I was uncomfortable, and I said something stupid to her, or I walked out of the room. And I know that's not what I should have done, but I was struggling, and that's why I exhibited that behavior. Then we hear from the teacher's perspective, and hopefully that's going to support what our student was saying. Then we get to the two biggies here. Determine if this conduct was caused by or had a direct and substantial relationship to the student's disability. This is generally the key question. Have we done enough in section 1 to show that the behavior in section 2 really was driven by that disabling condition, the thing that student struggles with? The answer here being a yes means it's a manifestation. Therefore, discipline of greater than 10 days is off the table for this student. So question 4 is an interesting one, and we're going to have a case on this coming up. Was the behavior the direct result of the district's failure to implement the student's IEP? This is another way to get a manifestation determination in your favor, is did the district not do what they were supposed to do for this student? And that failure, giving that accommodation, would have prevented this from happening, but they didn't give the accommodation. We're going to see 2 cases come up where this was truly what happened. In one of those cases, the school said, yes, we fell down here. So not only did they answer yes to number 3, but they also answered yes to number 4. And then in an interesting case, we'll talk where we got a yes on one and a no on one, but they should have both been yeses. So we'll go to the next one, Renee. Okay, QT. This is the one yes and one no. QT had an IEP for autism spectrum disorder and ADHD. Another piece of the puzzle is QT is a verbal child, but at school, from the moment he leaves his parent house until he gets home, he speaks to no one. No diagnosis of selective mutism, but that's how he presents at school. He has no friends, no one talks to him, and part of his plan was that he was allowed to email teachers. So QT's family came to us after an MDR hearing had already been held. And I asked the family about this, and they told us, yeah, we think we had an MDR. It was a really quick meeting. It took like 10 minutes. We questioned who was there. It was the principal, the parents, and the child. They called it an MDR. They told the parent this was not a manifestation, and they were moving to expel the child. So what did QT do? QT was in class, and one of QT's accommodations is that he is allowed to have multiple screens up with calming visuals. They're kind of like wheels that turn. Other distractible things, kind of like kids who have fidgets, he's allowed to have screens up. And on this day, QT had a substitute teacher in his class. And as teachers do now, they can check and see with the Chromebooks, what's QT up to? What's everybody in the classroom up to? And the substitute teacher went ahead and shut down everybody's extra tabs, but for the assignment that they were working on. QT, because he doesn't speak at school, sent an email to his teacher. Now, again, we have a sub in the front of the room, and we have the teacher at home. I believe teacher was out on maternity leave. And QT said, hey, open up my tabs again. And the teacher responded back, you should be doing your work. I don't know what you're working on. I'm not there. And then QT responded again, you don't want to see me get mad. Open up my tabs. This is the behavior that was deemed a threat. You don't want to see me get mad. and QT was brought into this expulsion hearing. So remember, families already attended what the school was calling an MDR, and now they hire us and we come to the expulsion hearing. And at that expulsion hearing, we hear a little bit more about some background of QT. And this is where we have that creative writing prompt in late October to write a scary story that QT decides that one of the main characters who is in his scary story happens to have the same first name as a classroom teacher. And this gets brought up in our expulsion hearing. You know, you have a history of making threats against teachers. QT doesn't speak. His guardian parent read his statement at our hearing. QT didn't associate what he wrote with being the teacher, right? This is the first time he's heard of this. And it was a very general name like John or Sam, something not out of the ordinary, no last names. One of the characters in his gory story had the same name as one of his teachers' first name. So all of this is brought up at the expulsion hearing, and I can tell from QT's demeanor and his lack of input that the school really just wants to be done with QT. They make him uncomfortable. They don't understand him. They bring up that he doesn't talk to his teachers. No one really knows him. QT did bring a couple of his service providers, county caseworker, to that meeting, again, similar to our other student. And QT actually spoke with his county caseworker. She had a better understanding of who he was. It's also important to note at this point in time, they've had the MDR. We're at the expulsion hearing live. They have not yet provided me with records. I have no student records from the school. I only have what the parent has given me. And I see that this student has an accommodation, that he is allowed to email teachers when he needs something. It also has the accommodation that he is allowed to have other screens up while doing his work to help him focus and keep him regulated. So I'm pretty certain if I get another bite at the MDR apple, I'm going to show that they didn't follow his IEP. The other issue is, was it truly an MDR? Did they have the requisite people around the table to make that manifestation determination review? At the end of the expulsion hearing, this principal says, you know, he doesn't belong here. He belongs at our alternative school. He doesn't have any relationships here anyway. This is the second time he's made threats against a teacher. I'm not making any decisions, but I'll send it to you in the mail. And we go home. I do a very heavy letter to the district, and they have not brought an attorney. Another interesting point about this district, they were unrepresented by counsel. I think it would have been much quicker if they had been. And I let the superintendent and the principal know that I believe the first MDR was deficient in that the right people were not around the table. I believe that they didn't consider anything in this student's record, given the fact that the copy of the IEP I had clearly showed that he had accommodations which were not being provided. And we wanted another bite at this MDR hearing with the right people around the table. They don't respond. And a day later, I get the expulsion notice. And shortly thereafter, they respond that they will grant my request for an MDR hearing. So about 5 days after the expulsion hearing, we have our second MDR, and they finally bring the special education team from the district to the table. We do it by Zoom. It's very apparent all of this behavior was a clear manifestation. The team decides such in the meeting. The team does not agree that the school failed to implement the IEP as written. But we have already the manifestation ruling. With the manifestation ruling, expulsion is off the table. This principal and superintendent sent a subsequent letter saying, now you got your MDR ruling, we're still expelling. We have pointed out now to them the law. They're not entitled to expel him, to remove him. They instead need to find a way to support him in his environment and keep him at school. Was about 2 weeks' time that passed with all of this. And the parents with the county caseworker had gone to an alternative school setting and actually loved what they saw. Had teachers who engaged with QT. He made a friend there in a very short amount of time. So for me, this is a mixed result because this school got their way. QT was out, but because the parent chose to not bring QT back, but they did get the manifestation ruling. The expulsion was off the table, and the documentation now shows that he was parentally placed at this other location, and he is also doing better. But this was just an interesting one for me because the nature of how it kind of unfolded and how a district thought they didn't have to follow IDEA. What they considered an MDR was not an MDR. And had the family not gotten us involved, he would have been expelled. It would have been problematic for him going forward. I suspect that this district also would have denied him any special education time that he was entitled to while he was out. So that would have also been unfortunate. So since students who are excluded from school who have special education services that they receive are still entitled to those services even when they're expelled, it's a really good thing to fight for, to make sure that your student is still being supported, even if they do end up not getting the MDR determination and being removed from school, they're still entitled to those special education minutes. We'll go to the next slide. So these are the three results at a manifestation determination hearing. We've already talked about a few of them. The conduct is a manifestation. The student returns to school immediately. In most cases, there's a little star there because it's not really there. I see it, but it's not there. The school might need to do some things to support the student in the immediate aftermath of the suspension. They've probably been out a few days. The IEP team may want to do a functional behavior assessment or a behavior intervention plan. Sometimes they just do something like a re-entry meeting where the student will check in. But that student's record should not reflect beyond the manifestation date that student was out of school on any out of school suspension time. If the conduct was due to the school's failure to implement the IEP, they need to go in and figure out how they're going to put those services in place so that student gets what they are entitled to. And then if the conduct's not deemed a manifestation, that student again faces the same discipline. They can be removed. Manner and duration is the same, and they will be entitled, as we just said, to their special education services that are outlined in their IEP while their punishment is enforced. We'll go to the next one. Okay, this one is one of our crazier cases. I'll go through it quickly in the interest of time. We have another student who has, again, oppositional defiant disorder. He's got a really comprehensive written plan, and there's almost a quasi-directive to all of his teachers in his 504 plan about some of HS's specific things he struggles with. He has a real problem, and I would suspect in addition to oppositional defiant disorder, there has been some traumatic event in his past where even the mention of police causes this kid to go into fight or flight mode. HS is on the bus with his friends after school, throws a magic marker out the window at a car. The car pulls up alongside, screams at the teacher. She pulls over, asks everybody who threw the magic marker. No one says. Finally, someone says it's him. Let's get moving. They all want to get home. And the bus driver says, nope, we're going to wait here and I'm going to call the police. And upon mentioning that she's going to call the police, HS jumps up and tries to get out of the bus. She won't let him. She won't let him pass out the front. He opens the back door of the bus, the emergency release, and jumps out on the side of the road. HS is restrained by an officer and, with parents' permission, ends up being sedated in the back of the police car. More trauma to a kid already traumatized. And we now go to our MDR hearing. He makes a statement. He explains what was happening with the throwing of the magic marker. I would say that the throwing of the magic marker out the bus window is dumb and stupid and dangerous, but likely it would have been very hard to tie that as a manifestation. Where we got the manifestation ruling here was the school's failure to implement the IEP. This bus driver had no clue about HS's issues with police. There was a real chance that, given the nature of the kind of template that was provided to teachers, hey, if you have HS in your class, these are the things that we want to do to support him, and these are things, you know, we should avoid. That was never told to someone who would be a custodian of that student, the bus driver. So we got the MDR ruling based on the fact that the school failed to implement that by failing to get one of his people on board with some of the things that HS needed to be successful. He was back in school. We wrote a more robust plan for him. Criminal charges were filed, and subsequently he went through a diversion program. Those were dropped. He's doing better. Danielle may know, I would suspect HS now has an IEP rather than a 504 plan. This was a kid that the school really needed to say, hey, we might not be supporting him well enough. He needs to have a safe person that he's checking in with when things get tough. He's had some trauma, and hopefully HS will stay on the right path. I know I'm getting to the end. Let's go to the next slide.
I was going to give you your warning, Ruth. You got about 8 minutes.
So IEP team doesn't reach consensus in that MDR meeting. School's district representative for special education gets to break the tie. We've had it go. 11 people in the meeting say it was a manifestation, and a principal saying it wasn't. He was number 12. Special ed director agreed with the 11, got the MDR there. Special considerations, and I know we had a question in the chat recently about weapons and acts of violence. The law has recently changed, allowing for a longer time out of school to be proposed when weapons or acts of mass violence are on the table in a threat. It's now 180 days. The other interesting piece about that is that it is renewable. So before, we put students out of school potentially for 80 days. Now, if weapons are used, it could be 180. And prior to that student coming back, that team can reconvene to determine if they think it's safe for that student to come back to school. So that's a special consideration. Always have your procedural safeguards. If you don't get it the way you want it in the MDR, mediation, due process, state complaint, district still must provide the special education time when the student is out. Next slide. These are just the big takeaways. I think they've been hammered home. I did want to do some lessons learned because I thought these were even more interesting. Just some practice notes from our time. When you're going around that table at the MDR and everybody gets to say whether or not they believe it is a manifestation, we've reviewed the records, we've talked about the behavior, and then everybody in that room gets to say yes or no, I think it's a manifestation. My takeaway here, lesson learned, I never let the principal go first. If I can help it, I want those teachers, those intervention specialists, the school counselor, I want all of them to speak up first. We have had a case where a teachers started to talk about believing it was a manifestation, and a very strong principal said, I'm going to go first here, and lay down the law that it was absolutely in no way a manifestation. I think it changed the dynamic in how those other people on staff at the school felt at that meeting. Everybody got really quiet, and it didn't go our way. Next, control the evidence. If you haven't seen the entire Snapchat or text screen for your student, and the school has, be very mindful that it may not be part of the record. Okay. I had a parent insist that his student offered to sell drugs to another student only after being badgered and relentlessly pressured into bringing a vape pen to school for that student. I had not seen the texts. They were not part of the record. The assistant principal had them in his possession, and the father insisted on looking at them. They very much showed no impulsivity on the part of our student. It actually showed that our student was actively a participant in the sale of a vape pen. Again, control the evidence. If you haven't seen it, it doesn't come up at the hearing. You don't know what it says. Another good practice tip, if multiple code violations are on the table, we have gone to an MDR where we have split those up and made the determination that each behavior was or was not a manifestation, especially in this instance with the weapon, the new law on weapons, when 180 days is a possibility. If we can divide up pieces of that and maybe something is a manifestation, but something isn't, maybe we could get less harsh punishment if we can get a manifestation ruling in a broken down code violation. Code of conduct. Check the code, read the entire code. Schools generally jump to the highest level when they're looking to expel. See if your student's behavior matches a lesser violation. Sometimes some of the code violations are about subsequent acts. Really, really be familiar with the code. Corianne mentioned earlier that you need to make sure the IEP is specific, so that you can get that relevant information in there. Again, for the ADHD with impulsive behavior, if your student has a history of walking out of class or saying dumb things, is disrespectful to teachers when he gets challenged, or has destructive behaviors, write it in there, get it in there. And that for me is if there's a next MDR, even if you don't get the MDR ruling, if you document what that student has done in this instance in that student's records, subsequently, if there is another proposed 10-day out of school, you can then go back and say, hey, we didn't address it as one of his, related services, but remember in June of last year, we dealt with something very similar. Let's look at the documentation. So put it in the records. So I guess I'll open it up to any questions we might have.
Hi, Ruth. We did have a question that I answered partially, but I sort of wanted you to expand on it verbally a little bit. The question was, what does it look like if the student has no 504 IEP or anything before an incident occurs? Can an issue be identified afterwards and still meet a manifestation standard to address issues newly being found? I answered partially to say that if the district is on notice and there were a pattern of behaviors happening, then absolutely the student should be entitled to an MDR. You might be limited to whatever you all are assuming is the disability if he doesn't have something diagnosed or hasn't been evaluated, but you can still get an MDR. So I suggested asking for an evaluation and then maybe having an MDR, which would push it outside of your timeline, but it might be a better result. But alternatively, if there were no behaviors, like no pattern of behaviors, but maybe something because of this incident, there's an indication that there might be a disability, or, you know, because of the incident, the parents take him to a therapist or a doctor and he gets diagnosed. What's the suggestion then, right? You can still make the request, but I sort of just wanted to see if you could hash out like the timeline. Obviously that's going to be modified, but how that could work.
Right. So there's not going to be an offer of an MDR if the parent hasn't raised the request yet. It's probably just going to go first to that informal suspension and then the formal expulsion hearing. I would always still talk about it. You have that sympathetic party there that's able to say, hey, you know, you have identified it. Maybe you haven't launched that process. We also have this question of, should the school have done something prior, right? Is it essentially a child find issue to have allowed this student, you know, to exhibit these behaviors and they go unchecked until it becomes something of this level? So I would always tell parents to raise it up. Hey, you know, I've been asking about it. We've talked about Bobby's behavior at every single one of our IEP at every single one of our parent teacher meetings. I've been getting notes home, you know, even if it doesn't look like a formal request for evaluation, I would bring that up at that expulsion hearing, just to say, you know, we're trying, but do document it and make sure that you're always anticipating that there could be a next MDR, a next expulsion hearing, and modify your writings of your 504s and IEPs to reflect that. I think with that, I've gone 2 minutes over my time, so I think we are on a break until 1 p.m.
Yep.
And is that correct?
Yes, yes. Thank you, Ruth, for your presentation. By the way, it seemed like we had a lot of engagement, some good questions that were being answered. So thank you for that. And yes, we are on our break until 1:00 p.m. So everyone can go eat some lunch. In the chat, we have our evaluation for Ruth. She values your feedback, so please fill that out. And we will be back at 1:00. Enjoy your lunch and enjoy your break.